Thanks, Jeremy. Thanks, everybody. I saw a lot of familiar names out there. I also saw a lot of new names. So I really appreciate your joining today to talk about spaceflight participants. I'm going to share my screen and get us started. So again, good morning. I'm going to talk this morning about national legal aspects of spaceflight participants and space tourism. I anticipate that this should be about 45 minutes, so we should have plenty of time for discussion and questions towards the end. So again, just to sort of enhance what Jeremy said, I am the co-director of the Center for Air and Space Law at the University of Mississippi. Our focus here is supporting commercial space and supporting the aviation industry. So we're looking at sort of the crossroads. You know, we see space now at the same place that aviation was back in the 1930s, and looking back into history to see how we can best support our commercial space industry into the future. We also consider ourselves the bridge to a spacefaring humanity. And so another thing that's very important for us at Mississippi is looking at things like human rights law in space. What will communities look like in space, and building the foundation we need in order to assure that we have sustainable and successful communities in space. And actually this concept of the spaceflight participant is a really vital piece of that sort of puzzle of putting together what we need for space, and also the interaction between commercial space and government space and military space. As mentioned, I'm also the co-founder and president of For All Moonkind, the only organization in the universe that is focused on protecting human heritage in space. And so what do we mean? You think first about Apollo 11. Of course, you know, none of those sites are protected, not Luna 2, first hard impact, Luna 9, first soft impact on another celestial body. And so we're really, at For All Moonkind, we're working within the United Nations and with the international community to build a convention that would protect our heritage in outer space, starting with the Apollo lunar landing sites. And again, this is also has huge implications with respect to space tourism and spaceflight participants, because presumably, or hopefully, those sites on the moon, those first human footsteps off of our own Earth, will become major tourist attractions and something that will always be a source of inspiration for generations to come. And finally, as mentioned, I'm president of the National Space Society. If you all haven't joined, you should. We are the Citizens Society, the Citizens Advocacy for Space Settlement and building communities, human communities beyond Earth. And so what we really, we are giving voice to people who may not necessarily be engineers or astronauts, but still have visions of living off the Earth. So, so here's the agenda for today. We'll just talk about, you know, what is space tourism, and look at recent events. We're going to look at what kind of law applies, air or space law. And then we're going to focus in on US law and this concept of spaceflight participants and why that's so important. And then we're going to look at what's missing. So what is space tourism? Dr. Stephen Hobe, writing in 2007, wrote, "Space tourism denotes any commercial activity that offers customers direct or indirect experience with space travel. Such activities have many different designs." You can read the rest. But what was interesting here, and why I put it in, is it was very sort of detailed, and it didn't talk about visiting other celestial bodies. So even in 2006, 2007, we still hadn't really, as a community, really sort of embraced or internalized the concept that it's not just on orbit that we're going to go, but we're going to send tourists to other celestial bodies. And so writing this year, Dr. Polkowska wrote, "Space tourism can be defined as human space travel for recreational purposes." So that is a much broader definition. But I also take issue with this because I think we're really looking at a time when space tourism is on this sort of this fine line between space explorers and space tourists, right? Because in a sense, and I want you to think about this as we go through this presentation, in a sense, everybody who is taking that risk of going into space, especially the people who are paying to do that, they are actually funding our future into space, right? And they are actually guinea pigs in terms of testing these flights, testing the ability of commercial space to build safe launch vehicles. I just this morning, the news was again revealed that there was an issue on Inspiration 4 when one of the, I guess, pee leaked out under the floor. And so, right now we are living in a time where every launch of a human, of a non-government human, is something new and something to be tested. And so I see a fine line between this concept of tourism and this concept of explorer. And I think it would help, because one of the things we're struggling with in the space industry is this backlash against the billionaires, if you will. Why are we spending all this time on space when we have so many issues down here on Earth? When we all know, I think everybody on this call would agree, we are going to solve problems with the resources and learning how to utilize more resources from space, and then sort of recasting tourists as explorers, as these risk takers who are advancing humanity, I think would go a long way towards sort of destigmatizing space travel. But ultimately, it has been said that the market for global suborbital transportation and space tourism is expected to reach 2.6 billion by 2031. So this is a growing industry. Of course, there are also stumbles. I mean, I think a couple commercial flights have either been delayed or canceled due to lack of enough people to pay the price. But again, if we can build a thriving suborbital tourism, that can fuel sort of orbital tourism and bring prices down for everybody. So tourism actually started, I'm sure we all know, with Dennis Tito in 2001, the first non-government individual, the first to go to space station. 7 tourists were shuttled to station between 2001 and 2009, all on Soyuz capsules. And so these were really our sort of pioneers of space tourism travel. Of course, they were flown on a government vehicle. When they got to ISS, they were the responsibility of the Russian government. And so they had to abide by the code of conduct of ISS. And so even though they were quote unquote civilians, they were very regulated and came within the purview very clearly of the supervision of the Russians, and were regulated by the Russians. Now, these individuals also, I would argue, this concept, are they tourists, are they astronauts? Again, these were risk takers. These are people who also did experiments while they were up there. And so it's really the concept of tourist, I think, is something we really want to think about in terms of how we're going to treat these hardy humans, the first humans to really start making the concept of going to space much more common. So then, of course, we jump 2 decades, we get to, or a decade and a half, we get to Virgin Galactic and the Virgin Unity 22 mission that went into designated airspace for airspace. So the Virgin Galactic is a longer journey. It flies tourists, flies explorers, flies risk takers, pioneers, up to just below, up into suborbit, not over the von Karman line, but enough to see the Earth, the curvature of the Earth, and to experience that weightlessness. But I put in here, Virgin Unity 22's mission flew out of that designated airspace for 1 minute and 41 seconds before pilots were able to correct course. So even this very first flight by commercial space with entirely private individuals did not go entirely according to plan. It flew out of its designated airspace for 1 minute and 41 seconds. That resulted in investigation by the FAA. But again, just putting that out there to show you that while these first flights look like they went off really well, they didn't. And every time we're talking about these little errors, they are all things that we need to be able to correct in order to assure the safety, not just of the participants themselves, but of our airspace and of our space. Of course, the next flights were Blue Origin. The first one flew also last July, and this was a orbital flight. It went up beyond the von Karman line. It's a very short flight, but if you haven't heard William Shatner talk about the impact he had, what he felt, really articulating Frank White's concept of the overview effect really beautifully and very movingly. Even that short period of time to enjoy that perspective of Earth was really impactful. Moving beyond, sort of as I'm sort of escalating us up into higher and higher orbits. The next flight we had was Inspiration 4. Crew Dragon circled the Earth for 3 days, so a truly orbital flight before splashing down the Florida coast on September 18th. The 4 spaceflight participants on Inspiration 4 were very busy doing experiments, interacting, communicating with people on Earth. And again, as I noted earlier, this did not go off perfectly. They had issues with the toilets, but again, this concern because the urine has ammonia in it. What would that do if this had been a longer flight? Would the urine have contaminated or corroded anything instrumental or substantive within the capsule? So having these 4 people go up as spaceflight participants, again, they were pioneers. They were able to take this capsule and be in orbit for 3 days and notice that these things were happening and help us build that safety record. The next mission that's planned, is that we know of, is this Axiom Mission 1. It's a planned SpaceX Crew Dragon missile to the station. These gentlemen will stay on station for several days and then come back. So you're seeing these sort of different implications of these different kinds of space tourism, right? So we have suborbital flight with Virgin Galactic. We have suborbital flight crossing that von Karman line with Blue Origin. We have Inspiration 4 going into orbit, and we have Axiom 1 actually visiting station. And then we also have the Dear Moon project. So this got a lot of press in 2018, not all good press because Yusaku Maezawa started to try and use this as a dating game at one point. But this Dear Moon project is planned to take place in 2023. And this would actually take civilians, non-government individuals, private individuals around the moon. And so this is so far the farthest we're looking at in terms of sending people, individuals, tourists, pioneers. This is the farthest we're looking at. And so those plans were announced in 2018. He had a contest in 2021. I think over 1 million people responded. This entrepreneur paid for the flight himself, and he wants to choose 8 crew members to join him out of this applicant pool of 1 million. He is also planning, I think, on going back to ISS himself. So, and in addition to the Axiom program that I talked about in the previous slide, Axiom Mission 1, we also have a Russian actress who was on station just last week. We have the possibility that Tom Cruise will go to station sanctioned by NASA. And we have this trip by Yusaku Maezawa also planning to go to station. So station itself seems to be opening up to tourism, which brings another whole issue of how to treat the individuals who are there, but not necessarily on the government's under the government's responsibility. And finally, we have private space stations. Axiom Space, of course, is building or talking about building a station, and just announced yesterday or the day before, Blue Origin says it will create a space station that will be sort of a mixed-use business park. They're going to call it Orbital Reef. And Jeff Bezos has said that by the end of the 2020s, it will become the premier mixed-use space station in low Earth orbit for commerce, research, and tourism. So this is a really fantastic idea. But again, when we're looking at an entirely commercial space station, what does that mean in terms of liabilities, responsibilities, obligations? What is going to be the difference? Are we going to treat tourists differently from scientists? Are we going to treat, presumably, the U.S. government will also want to do research here. Will we treat U.S. government employees differently from people who are there just for the fun of it for a weekend? And should we treat the people who are there for a weekend differently, both in terms of liability and in terms, you have to think about rescue, return and rescue. So that's sort of the scope of what we're looking at in terms of space tourism. So definitionally, when I talk about space tourism, I'm talking, I don't like the term recreational, but I like to think of it more of as just any time we're sending a non-government individual into space. So to me, we will have commercial researchers, we will have commercial laborers in space. And so, we'll see that in the United States, we've separated this definition of sort of crew and participant, but perhaps there ought to be an umbrella definition, again, for anybody who is willing to take the risk to go into space during these early days. So what are the obligations of a state with respect to a tourist in space? So a legal obligation is owed by a state as imposed by a convention, treaty, or other legal duty. So a state has an obligation imposed, in this case, by the Outer Space Treaty, but there's also sort of customary international law with respect to liability, potential liability of your nationals. So an act by the state which breaches that obligation, or a failure to act by that state breaches that obligation, there's a link between that breach and the damage caused, and then the state is responsible to compensate for that damage. The state has original responsibility for its own acts or the acts it's authorized, and also vicarious responsibility for unauthorized acts by a state agent, a national, or an act within its territory. So a state can have vicarious liability for any of the commercial entities which it is supposed to govern. The standards are due diligence and what a state knew or should have known. So the first question we have, we have a concept of liability. We know that a state under customary international law has some responsibility to make sure that its nationals don't put the rest of the universe at risk. But the very first question we have to ask when we talk about space tourism is what law applies, because there are different, in addition to that customary obligation of states to take care of and prevent damage, there are also treaties. And so if you recall back in July, there was a sort of bickering back and forth between, I shouldn't say bickering back and forth, there was a competition and Blue Origin took the extraordinary step of creating this infograph on Blue Origin versus Galactic, and Blue Origin says it flies above the Kármán line, internationally recognized boundary of space at 100 kilometers. So that is technically not true. There is no internationally recognized boundary of space. We have the Outer Space Treaty, we have the Warsaw Convention, which covers airspace. Neither of those treaties just have a demarcation line of where air ends and where space begins. So fundamentally, the very first question we have is, okay, what are we talking about? Are we going to call Virgin Galactic participants space tourists that come under space law, or are they, because they don't technically cross that von Kármán line, which is not the internationally recognized boundary, but sort of the most commonly accepted boundary of where space begins and where air ends. And what does that mean in terms of liability? So the international air travel has been governed since 1929 by a private liability convention. It's the most successful of its kind. It was negotiated in the 1920s because governments realized the power of flight and realized also that we needed to harness that power and we needed to support the growth of the air industry. And so nations came together and created the Warsaw Convention, which states that liability for that risk, individuals will have to take that risk of flying on an airplane because we want to protect the industry, and we're going to cap liability of this industry so that they don't get bankrupted or crippled by accidents. And so the very first treaty limited liability to $8,500 per incident, per accident. This has been gone through many revisions, and now we have the Montreal Convention of 1999, which has it up at 100,000 SDRs. And you can go beyond that if you can prove misconduct or a gross negligence. But again, the concept is if you're on a Virgin Galactic flight, and there's been a discussion of this in email boards and so forth, but right now, these suborbital flights take off and land in the same jurisdiction. The Montreal Convention does not apply unless you take off and land in different nations, different states parties. Apparently, Virgin Galactic, takes off and lands. Or Spaceship Two is going to take off and land from Spaceport America in New Mexico. Its backup airport is in El Paso, Texas, but the backup to that is in Mexico. And so, in the not what's the word? It probably won't happen that they will have to utilize the Mexico option. And so this is kind of an academic discussion of would the Warsaw Convention, the Montreal Convention apply to the spaceflight participants who took off from Spaceport America in New Mexico and landed in Mexico because they are now an international flight. It is not very likely to occur, but think about what we're moving towards in terms of suborbital flight. There are a lot of people talking about using suborbital flight to get people across the world faster. And so it's very soon we might have those suborbital flights transferring passengers from the United States to, for example, Australia in far less time than it does takes by conventional aircraft. And so at that point, are we going to call those suborbital flights space flights, or will they be aircraft flights, and therefore, two very separate regimes. Again, one very protective of the industry, and the other sort of right now, unregulated or improperly regulated, or regulated in a very undetailed and broad fashion at this point. So, at the University of Mississippi, we're sort of looking at, well, maybe we need to adopt something like the Montreal Convention for commercial spaceflight because we want to protect it. But that's neither here nor there for this conversation. In any case, the first question you have to ask before you even think about spaceflight participant is, are they really a spaceflight participant? And so now we'll go into the actual definition of what a spaceflight participant is and why we have to define them. So everything that we do, space, people consider it this sort of final frontier, the wild, wild west. It's not. We do have several treaties regarding space law, the Magna Carta of the space law being the Treaty on Principles governing the activities of states in the exploration and use of outer space, including the moon and other celestial bodies. And I highlighted principles and states because it's very important to recognize that this is like a Magna Carta. It doesn't have sort of decisive rules. It just offers principles, and it governs the activities of states. It does not govern the activities of individuals directly, and we'll get into that. So the first and most important aspect of the Outer Space Treaty is that space is the province of humankind, free for exploration and use by all, free access to all. So space is this concept of anybody can go to space, if you can. And so the concept of being able to promote space tourism, to just go up and do whatever you want, that is enshrined in the Outer Space Treaty. Outer space is not subject to a national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. You don't need a passport to go to space and come back at this point. But this is, we're sort of forward thinking in terms of what are we going to do about hotels on the moon or hotels on orbit? Certainly having station ISS in orbit is occupying that orbit. That's something we haven't really thought about yet. But as we get to the moon and think about building human communities, building bases, building museums, we're gonna have to think about what that means with respect to national appropriation and property ownership. Article 5 is the talks about astronauts, and out of Article 5 came a separate agreement, the Return and Rescue Agreement. So under Article 5 of the Outer Space Treaty, astronauts are envoys of all humankind. They shall be rendered all possible assistance in the event of accident or distress. So if we have a Chinese space station and a US space station and a commercial space station, if everybody in space at that time are considered astronauts, if anything happens on any of those stations, everybody who is able to render assistance must, if they've signed the Outer Space Treaty. Drawing off of that, the Return and Rescue Agreement sought to sort of pick out more details. And Article 3 says, parties shall extend assistance in search and rescue operations if it is discovered that personnel of a spacecraft have alighted on the high seas or in any other place not under the jurisdiction of any state. It's important to note, you read the Return and Rescue Agreement, it's very much driven by if something lands in your territory and it belongs to somebody else, you have to return it. If the personnel of a spacecraft land in your territory, you have to render them assistance. And it's just this one concept of on the high seas or in any other place not under the jurisdiction of any state, where we think about, okay, space is not under the jurisdiction of any state. So if it's discovered that personnel of a spacecraft, okay, is there a difference between astronaut and the personnel of a spacecraft have alighted in a place not under the jurisdiction of any state, then parties shall extend assistance in search and rescue. So this is an obligation, arguably, that any state who has spacefaring capabilities has to assist if there's an accident or there are personnel of a spacecraft in distress in space. So again, you know, when we talk about interpreting treaties, the Vienna Convention on Treaties tells us that we need to look at the words that are used. So we've gone from Article 5 of the Outer Space Treaty talking about astronauts, and now in the Return and Rescue Agreement seems to, I think, broaden that concept. You know, astronauts feels like a very sort of I don't know, I was going to say romantic, but, you know, I think people have visions of astronauts. And so personnel of a spacecraft seems to open that concept up a little bit more, at least to me from an emotional standpoint. Article 7 talks about liability. So each state party to the treaty is internationally liable for damage to another state party. And I want you to look at this concept. There's 4 ways a state party can be implicated. Launches, so that's if SpaceX launches, then that's the US. Procures the launching. So arguably, if a Japanese individual has purchased the SpaceX flight, then that Japan has become the launching state. Each state party from whose territory, again, if you're launching with SpaceX, it's going to be from the United States, or the facility. And in some cases, you can have the facility in a separate territory, but the facility owned by another nation. So every launch has the potential to have 4 launching states and 4 potentially liable nations. The convention, again, like the Return and Rescue Agreement, the Article 7 produced its own convention to try and detail what it meant. Article 2 says the launching state is absolutely liable for damage caused by its space object on the surface of the Earth or to an aircraft in flight. So if your spacecraft doesn't make it into orbit and lands in somebody else's territory, that state is absolutely liable. So Article 3, if it happens to on orbit, then we're at a negligence standard, but we're looking at sort of different to person or property on board such a space object by a space object of another launching state. So I want you to look at and think about, again, we have this concept of space object. So you're liable for a space object, but what if you have a spaceflight participant up there and that participant does something that causes damage? Is the spaceflight participant a space object for purposes of the liability convention? And again, I put this in, so if you are actually a participant in the launch itself, then the liability convention does not apply to you. Finally, Article 9 of the Outer Space Treaty, these are the only sort of responsibilities. Article 4, I think probably most of you know on this call, Article 4 is the peaceful purposes of space. You're not allowed to put WMD or nuclear weapons in outer space, on orbit, sorry, or on any other celestial body. But with regard to spaceflight participants in space tourism, we also need to talk about this, the only restrictions on those being that you must act with due regard for other states' parties. You have to avoid harmful contamination of other celestial bodies and also adverse changes in the environment of the Earth. So I said that the Outer Space Treaty governs states only, but Article 6 is what brings the responsibility of the state into our national law. Article 6 states that nations shall bear international responsibility for national activities, including those by non-governmental entities. And it's not just that the US is responsible for these non-governmental entities. They're responsible for assuring that national activities are carried out in conformity with the provisions set forth in the present treaty. Okay, so non-governmental entities would include both the space operators and the spaceflight participants. And so all their activities must be carried out in conformity with the provisions set forth in the Outer Space Treaty, which is why we needed to look at that. The activities of non-governmental entities in outer space shall require both authorization and continuing supervision by the appropriate state party. And so that's how we got to the point where the United States has to take responsibility for spaceflight participants that are either its nationals or launched from the United States, and must authorize and supervise. And so that's where we get our regulation of commercial space launch activities. It's legislated by Congress in the US Code. With respect to 15 USC 50901, which that's just talking about the findings. So what does Congress want? And this is really important. Congress wants to develop commercial launch vehicles capable of carrying human beings into space and greater private investment, because they believe that Congress believes that this will stimulate the nation's commercial space transportation industry as a whole. Congress recognizes that space transportation is inherently risky and that the future of the commercial human spaceflight industry will depend on its ability to continually improve its safety performance. Congress recognizes this public interest in creating a clear legal and regulatory safety regime for commercial human spaceflight. And Congress recognizes that these standards must evolve so that we don't stifle technology development. So these were the marching orders from Congress to the FAA to say, okay, now FAA, go and develop regulations that will cover and regulate, in keeping with our obligations under Article 6 of this Outer Space Treaty, regulate human spaceflight. So the FAA split human spaceflight into two categories. Well, first we would talk about the definitions. So they split it into two categories: crew and spaceflight participant. You can read the definition of crew. I will, of course, share my slides with Jeremy so that you guys can keep them. But crew is basically anybody who is associated with the flight. The spaceflight participant means an individual who is not crew carried aboard a launch vehicle or re-entry vehicle. So two very distinct type of people that go into space. Now think about how do crew and spaceflight participant mesh with our international definitions of astronaut and personnel of spacecraft. So just more definitions going through, again, you know, the flight crew, the pilot, the remote operator are all members of that umbrella concept of crew. And then just I put these in because it's sort of interesting definitions of spaceflight incidents, of launch incidents, and talking about when liability will come in and when it won't, how launch accidents are identified or defined, and these have different implications for liability insurance. And also I just thought it was interesting that we had this different concept of mishap. And again, I put this in to show you, that there is definitely a different concept for suborbital. The federal regulations don't talk about whether suborbital ought to be governed by air law or space law. It just talks about this suborbital trajectory. And so here we get into the FAA regulations with respect to crew. Remember, we have two different types of, the United States has two different types of human beings that will go into space, crew and spaceflight participants. Again, here's your definition of crew, all encompassing, basically flight crew, pilots, contractors, and so forth. Crew has to be trained. Each crew member has to complete training on how to carry out his or her role. Each has to demonstrate an ability to withstand stress of space flight. Each one with a safety critical role must possess and carry at least a second-class airman certificate. So these are the only sort of training and qualifications required by the FAA with respect to crew and what the crew has to do, and recognizing that space flight brings this additional stress. In addition, the pilot and the remote operator must be FAA pilot certificate, possess and carry an FAA pilot certificate, and possess that aeronautical knowledge and receive special training for each phase of flight. The crew must be informed in writing of risk and the fact that the US government has not certified any launch vehicle or reentry vehicle as safe for carrying flight crew or spaceflight participants. So the Congress has specifically said, I think I talk about this later too, that we don't want to have the FAA regulating safety at this point. And then each crew member must execute a reciprocal waiver of claims with the FAA and Department of Transportation, so they can't sue the US government. The crew, and this comes under subpart A with respect to the crew, an operator must provide atmospheric conditions adequate to sustain life and consciousness for all inhabited areas within a vehicle. The operator or flight crew must monitor and control those atmospheric conditions in the inhabited areas. So when I teach this class, I kind of, sort of roll my eyes a little bit, because one would just assume that an operator would provide life sustain support systems, but apparently we have to regulate that they will. And again, it's regulated in this subpart A, which in respect of crew. So the crew has to, so the operator has to make sure that there's, you can sustain life. And then operator must provide an adequate or redundant or secondary action supply for the flight crew. There is no parallel provision for the spaceflight participant. So again, the concept of spaceflight participant is very different from the flight crew. Of course, it's the flight crew that will get the participants back to Earth safely, presumably. But just wanted to point out that we do have this requirement of life support, but that secondary is just for the flight crew, and then you can see what else there. So that's the crew. So we have the requirement of oxygen. We have a strict training regime. We have that waiver. Now let's move to what a spaceflight participant is. So we saw that it's any individual who's not crew, right? Before receiving compensation, so a spaceflight participant must be informed by the operator in writing about the risks of the launch and reentry, including the safety record, in a manner that can be readily understood by a spaceflight participant with no specialized education or training. And it must disclose in writing. I just chose sort of the three high level. The regulation goes on into more detail about what must be told, what the spaceflight participant must be told in writing before they can board that, before they can pay for their flight. The operator must inform each spaceflight participant that the United States government has not certified the launch vehicle and any reentry vehicle as safe for carrying crew or spaceflight participants. Congress has specifically set a moratorium on the regulation of safety of commercial human spaceflight until October 1, 2023. So that's already been, that was legislated, I think originally in 2007. It's already been pushed, that moratorium has been pushed at least once. So very clear, the government is not regulating the safety of these these launch vehicles of commercial human spaceflight. So what does that mean to me? That means to me that, okay, SpaceX has to meet certain requirements in order to be able to launch US government astronauts to station. So we know that SpaceX already has to meet certain safety standards. Virgin Galactic and Blue Origin are not required to meet any kind of safety standards at this point. Now, of course, the market's going to decide if something is safe or not, and it's obviously in the best interest of everybody involved to make sure that they are as safe as possible. But that's just something to think about. And an interesting, this is sort of the congressional answer to the Warsaw Convention. This is how Congress right now is going to protect this commercial human spaceflight industry by not imposing safety standards, which will likely raise prices. Before the flight, the operator has to provide an opportunity to ask questions. And then again, that participant must consent in writing to all of these things, and that they primarily also that they understand the risk. And spaceflight participants also have to waive their claims against the government. An operator must train each spaceflight participant before flight on how to respond to emergency situations, including smoke, fire, loss of cabin pressure, and emergencies. So this is the training versus that training for the crew, okay? Spaceflight participants don't need to know much. They just need to know how to respond to emergency situations. And remember, that if the oxygen leaks, they're not the ones who are first in line for that secondary oxygen. So that's the extent of our spaceflight participant regulations. And so what's missing? Again, we're talking about the Outer Space Treaty and that rescue agreement. What is the difference between an astronaut, the personnel of a spacecraft, and the spaceflight participant? What is the obligation of somebody, of a nation, to actually rescue or participate in the search and rescue? And I pulled this concept of search and rescue operations in the United States. In the United States Coast Guard, it costs about $680 million annually for the Coast Guard to search and rescue individuals. So these are individuals who may or may not have been taking extreme risks. They have the same kind of costs with the National Park Service, where we have, it seems like the trends are for people to take more and more extreme risks. So what are the responsibility of the people against the responsibility of the government to protect those people who are taking on these higher risk activities? And if it's $680 million annually for the Coast Guard, imagine what it would cost a Space Force or a Space Guard to rescue humans who are at risk in space. And what would that mean in terms of if, for example, China is obligated by the Outer Space Treaty or the rescue agreement to rescue those people? Does the United States have to pay China back? And then do the people have to pay the United States back? I mean, this is the more and more people we put into space, the more likely we're going to be in a position where they are going to need rescuing. And what is the US law with respect to that rescue? There is no law that says if we saw the spaceflight participant regulations, there's nothing in the spaceflight participant regulations that say if something happens to you when you're on your 3-day orbit, somebody will come and rescue you. I mean, that has to be very defined in the contract, that is definitely not an obligation of the United States. But is it? Should it be? The other question is debris. What are we looking at in terms of, now these launch vehicles have to meet certain requirements with respect to orbital debris, but what about the payload? What happens if something happens to the Dragon capsule and it's just floating inoperable? Is there an obligation of SpaceX to remove that into a graveyard orbit? Is there an obligation of the United States because it has to have due regard for the activities of others on orbit? Should the United States be required to remove that, and at what cost again? Health. So spaceflight participants will face myriad risks beyond the obvious perils of that initial rocket launch. You know, we've talked about the medical data on the effects of spaceflight on the human body. There's different risks with respect to how high you go, pre-existing medical conditions. You know, I sort of use a silly example, but imagine if, you know, that Blue Origin capsule is not that big. Imagine if somebody just has horrific motion sickness. And all of a sudden, we saw in Dragon, we had, the urine wasn't captured. What if somebody throws up? That's going to ruin my enjoyment of that space flight. But it is, what if something happens to somebody from a pre-existing medical condition? What if it's an accident? What if there's an accident, but the accident was exacerbated by somebody's health? Again, what is the U.S. government's obligation to an individual who might be on the Bezos Blue Origin business park in space if somebody has a heart attack there? There's not going to be an EMT ambulance ready to get there. So what are the government obligations to these spaceflight participants at that point? And again, liability, I touched on this, we talked about the launching state and how there's 4 different launching states. The launching state only has responsibility for a space object. So is a spaceflight participant an object? What happens if it's the spaceflight participant who does something? Does that absolve this, keep us out of this liability convention? The other issue with the liability convention is that a claim for compensation is presented through diplomatic channels. So the Outer Space Treaty does not recognize private activities in space. It all must go through these diplomatic channels. There is an opportunity to pursue claims in the courts of a launching state, but any plaintiff's attorney is going to want to go after a government because they're the biggest pockets. And so you can imagine that any sort of what I call a slip and fall in a business park could end up in a diplomatic morass. I wrote a paper regarding the different scenarios with respect to if something happens on a private space station, how many states could be implicated in a very sort of simple, what we would call on Earth slip and fall, and how this liability convention structure is really impeding the progress of that. And of course, criminal acts. So we saw last year the Anne McClain, being the first crime in space because she accessed the bank records of her partner from space to Earth. So what happens if there are criminal acts in space? What jurisdiction would we use? And we have a good model in the ISS Code of Conduct. It talks about the different nationality. It creates cross waivers, so we don't have to worry about that liability. It makes it very clear that nationals are subject to the laws of their own nations. It actually creates boundaries on ISS. So if you cross into the Russian compartment, then Russian law will apply. But we need to sort of expand on that. So the ISS Code of Conduct is a really great start in sort of thinking about how people are going to react in space and how we need to have structure in space. So one of the things that the Congress has said is it really wants to push voluntary standards. And so my argument, I would lobby for or ask the commercial space industry to formalize voluntary industry standards. But let's expand and let's think not just to the next paycheck. Let's not just think to the next space flight. Let's think to the humanity in space. So if we can build into these contracts some very basic human rights, the right to oxygen, the right to communicate with people on Earth, if we can standardize labor laws in these business parks, if we can standardize safety in these business parks and other orbital things, if we can recognize participants, at least for now, as explorers, I think that we then build the foundation we want for human communities in space. If our very first I'm going to call them explorers, spaceflight participants, are taking these risks, and they are actually laying the footprint for our future in space, we need to start giving them rights so those rights become recognized and inalienable. And so, in conclusion, this is what For All Moonkind is working against. We dearly would love to see a museum on the moon, but we certainly don't want to see people camping right up next to Apollo 11 on Tranquility Base or on near any of our historic sites on the moon. because obviously regolith, and that's a whole nother presentation. But again, space tourism is a wonderful and good thing. We still have a lot to talk about and think about with respect to how we treat those spaceflight participants and what the government obligations are to them. Thank you.
And I see that we have already gotten some questions into our Q&A. So let's open that up and we can get into some of these questions. First question is from Stephen Wood. He writes, in terms of liability, my understanding is that all launch states are jointly and severally liable. Is that correct? And I believe that you somewhat answered that later on in the presentation, but if you could just very briefly.
Yes, very clear that they are jointly and severally liable. And so that actually puts a government like the US government even more at risk, because if you have even if you have 4 different launching states for the definitional purposes of the liability convention, your plaintiff's attorney is going to go after the state with the biggest pocket, and that is generally going to be the United States.
Right, excellent. And I note that as I look at these additional questions, the next several are also from Mr. Wood. He next writes, also, quote unquote, spaceflight participants is not a term used in the Outer Space Treaty or the Agreement on Astronaut Rescue and Return. Do we see a gap there with respect to a state of registry's ability to call for assistance from other members of the Outer Space Treaty, et cetera? Again, something I think that you mentioned a little bit, but could you speak to that briefly, Mia?
Yeah, absolutely. Yes, I think so. I think it's a real issue. And it's curious to me that we didn't use that same language in the FAA regulation. Again, things are done for a reason, right? And so when you talk about that convention, the Vienna Convention on how to interpret treaties, we know that we have to, those are different terms and they were termed differently for a reason. They were negotiated, those terms were negotiated for a reason. So again, I think that spaceflight personnel of a spacecraft is something larger than astronaut or taikonaut or cosmonaut. But I think a spaceflight participant, I can't tell, and I think that's up to opinion and whether that actually broadens personnel of a spacecraft or not, and whether it was intentionally created. Because remember, in the United States, we have spaceflight participant and we have crew. So crew, I think, would be personnel of a spacecraft, right? I think that could be a logical jump, but spaceflight participant might be something less than that. And so it might be a way for a country to say, I mean, presumably you always have a crew member on orbit, and you can, the private companies can call their participants crew if they give them some responsibilities. But yeah, I would argue that if you have a spacecraft and it's just floating with without crew on board, if the crew is all remote and something happens, then there might not be an obligation legally. Hopefully there would be morally, but there would not be a legal obligation to participate in the search and rescue for that.
Excellent. I think that you covered the answers to Mr. Wood's 2 additional questions during your presentation, ma'am. So let's go ahead and jump over to a question from Alex Manchero. What role are insurance companies playing to help companies mitigate all of these risks that are involved in launching space tourists or spaceflight participants into orbit?
So right now, the insurance landscape is focused on that launch part, and the FAA has very strict, very detailed regulations about how much insurance a launch should get or a flight should maintain. And so the insurance companies have been meeting demands, and the FAA will actually say that you must be insured to this number, or they call it the maximum probable loss, or the highest amount that the insurance company will give you. I honestly don't know. So that's sort of on the launch part. I don't know if insurance companies are taking a different look at spaceflight participants, of flights with spaceflight participants, because it's not required by the FAA that you have any additional insurance because you have a human payload instead of non-human payload. And so I'm not privy to the contracts that people have, but certainly I would imagine individuals who are taking these risks will endeavor to get their own life insurance policies to cover certain things with respect to that. And I don't know how the insurance industry is responding to that.
Just gonna leave it open to see if any other questions flow in. I will just take another one of these questions from Mr. Wood. Again, I think you maybe spoke to it a little bit during your talk, ma'am. But Mr. Wood asks, what if the spaceflight participant themselves, right, does something that causes an accident on the space object or on the mission in which they're participating?
So I think that's the most fascinating question. Like I said, I wrote a whole paper on private visitors to station. But the first question is what is the responsibility of the U.S. government? So certainly that's a U.S. I'm using U.S. I should say a government. Certainly a government is responsible for its national to an extent, right? And under the Outer Space Treaty and the Liability Convention, perhaps that's more than usual, except that the Liability Convention talks specifically to that space object. And so is a participant an object for purposes of the Liability Convention, or can you argue that it's a person and so something else, something different? The standard is always, sort of that due diligence, what you knew or should have known. And so that begs the question of whether we ought to be having psychological exams or, background checks on anybody that we're going to allow to go to space for a longer period of time. So, these suborbital flights, I think we can hope that, 10 minutes up, nothing criminal or negligent or grossly negligent will happen. But when we're talking about sending people perhaps around the moon or just around the Earth more than 3 days, then you really are opening up this opportunity for negligence, and it could be a complete accident, but because somebody just wasn't thinking properly, maybe because they were staring out at the Earth because it's so beautiful. And so there is no clear idea or answer as to what the government responsibility is with respect to that person. Certainly from a contractual standpoint, that person and its operator, his or her operator, will have a contract, but I would imagine if something happened that impacted a third party, another spacecraft, especially one from another country, the U.S. will become implicated and involved in that.
We do have a new question that has come in from Patrick Klansek. Are the FAA or other U.S. governmental bodies actively discussing further updating the definition of astronaut? And if so, who is overseeing that process and providing input on that discussion?
So the only sort of chatter I've seen with respect to that definition of astronaut is with respect to who gets those astronaut pins, right? And so we've got different categories of astronauts. The FAA has an astronaut pin and it has a commercial astronaut pin. So there is no, they're still keeping that difference. They have not issued they haven't issued spaceflight participant astronaut pins. So I think they're going to sort of wait and see what happens with that. I think that there ought to be some sort of general and again, and if the industry could come together and instead of giving out, everyone gets their own dragon wings or Blue Origin feathers, whatever, if we could establish a standard and recognize people as explorers or pioneers, even if for a short period of time, or just decide some sort of conducts or behaviors or things that need to be done. I think that would help a lot in terms of both building the foundation we want for all humans in space, but also giving more credence to what people are calling tourist flights when they're really just flights that we're using to continue to evolve and perfect our vehicles and bring the cost of those vehicles down.
Now, I know that we're after the hour, so I understand that some people might need to leave. Additional questions are flowing in. So ma'am, as long as you're all right with it, are you okay with answering additional questions?
Absolutely.
All right, awesome. So our next question comes from R. Curtis McNeil. He asks, how can any nation assert jurisdiction over an individual in space, criminal or civil, not on a government vehicle? They appear to be outside the recognized jurisdictional physical limits of the nation state.
So the personal jurisdiction travels with the individual. And so if you think about an airplane in flight over the high seas, we would look at the flag of the, or even think about maritime law, you look at the flag of the vessel, right? And so that vessel, even in space, has to have launched from someplace and have been licensed from someplace. So at the very least, you would have that nationality based on the flag of that spacecraft, that vessel. So again, we would borrow from maritime law and aviation law to say which laws would apply to that individual. And you know, the concept of does the criminal code travel with the person? No, because you are bound by the laws in the jurisdiction in which you are located. And so what the Outer Space Treaty does or not is it takes that concept of the nationality and says, on top of everything else, we are going to make you responsible for your nationals. And again, that Article 6 talks about non-government entities and that requirement for authorization and supervision and that liability. And so the Outer Space Treaty really adds more liability and more responsibility and more obligation on a nation than is otherwise would be considered under international law.
All right. My prevarication has not yielded any additional questions at this time. Professor Hanlon, ma'am, do you have any final closing thoughts?
Oh, geez, wasn't prepared for that. I think that I will always take the opportunity to applaud our billionaires for what they're doing in space. I'm so disheartened by the tone with which they're treated in terms, especially after William Shatner came back. I think that we all ought to be really grateful that there are people who are willing to spend their personal fortunes to continue to fuel the human curiosity and human need to explore. So I'll leave it at that. And if you are at all inclined, go visit us at forallmoonkind.org and see what we're doing about protecting our heritage in space. Thank you.